Hello guys and welcome to Lawputra's YouTube channel. Today we will discuss about the divorce by mutual consent in Hindu law as well as Muslim law. I am Jagannath Kulkarni and I welcome you all to today's discussion. Before we proceed to what is divorce, let us think about what is marriage. Marriage unites two people for life and they allow them to fulfill four purusharthas. Number one, dharma or obligation, then artha or possessions, then kama or physical wishes, and ultimately moksha, that is absolute divine liberation together. Indian constitution recognizes marriage of two people as husband and wife. Issue arises when and where these two, husband and wife, are unable to coexist. And here the concept of divorce creeps in. Before we move on, let us consider how the marriage is looked at from Hindu law and Muslim law. Hindu look at it as a sacrament. Muslim look at it as a contract. Hindu law, polygamy not allowed. Muslim law, polygamy allowed. Hindu law, minimum age is 21 years for male, 18 years for female. Of course, it is underway that female's age also will be 21 years. But in case of Muslim, the minimum age is either 15 years or attaining the puberty. In Hindu law, there is no concept as such meher or dower which is to be given to the female, that is the bride. But in Muslim law, the dower is very important concept. Again, in Hindu law, the prohibition is on the Sapinda relationship. The relationship in Sapinda cannot marry each other. In case of Muslim law, there is legal disability for marriages. Now let us talk about the divorce. How the word has evolved. The word has come from the original Latin word dovertium, which is again the combination of two words, dis and vertere. Dis means apart, vertere means to turn. It simply means diverse. Dissolution of marriage. Divorce, in simple terms, it is the dissolution of marriage. It is the termination of marriage by legal formalities. Because marriage is a contract, if you want to break it, terminate it, you have to follow the legal formalities. So the divorce puts the marriage to an end. Parties revert to their unmarried status so that they can once again open to marry. Legal separation of two spouses by bringing an end of the vows which they have taken during the sacred ceremony of marriage, maybe Saptapadi or Havan or whatever. It would ruin the marriage life eternally and also difficult for children out of marriage to cope with the separation of their parents. So these are the divorce implications. Now, divorce under Hindu law, we have to refer to the Hindu Marriage Act 1955. Section 13, Section 13A and Section 13B. These are the three sections which result into dissolution of marriage. Section 13 is simple, divorce but contested. One party will file against another. Section 13A again is the alternate relief in divorce proceedings, which means it is a judicial separation, not divorce but judicial separation. And section 13B, which is our today's topic of discussion, that is divorce by mutual consent. Now, under Muslim law, we have lot many ways. And remember, Islam, perhaps the first religion in the world which has expressly recognized dissolution of marriage by way of divorce. So who are progressive? Let us see. It is because it prevents the conjugal happiness and interfered with proper bringing up of the children. So Prophet Muhammad was not in favor of divorce. Again, but now since they have been enacted or they have been codified, uncodified, extrajudicial divorce, which is the personal law or Sharia, which we know, Either it is a unilateral divorce, talaq. It can be divorce at the instance of wife, that is khula. It can be divorce by mutual consent. They also have this feature, mubarat. And there will be delegated divorce, that is talaq-e-tafweez. There can be the judicial separation and judicial divorce under civil suit. They have to file the civil suit. And there will be the constructive divorce, that is ila and zihar. These are the special concepts. But today we will discuss about the divorce by mutual consent, that is mubarak, and an instance that is khula also. First, let us talk about the Hindu Marriage Act. Section 13B, which is our today's topic, divorce by mutual consent. Subsection 1 says, subject to the provisions of this act, petition for dissolution of marriage by a decree of divorce may be presented to the district court, now family court, by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of 1976 Amendment Act of Marriage Laws. The grounds, there are three grounds. First, they have been living separately for a period of 1 year or more, that they have not been able to live together. And lastly, they have mutually agreed that the marriage should be dissolved. Subsection 2 says, on the motion of both the parties made, not earlier than 6 months after the date of presentation of the petition referred to in subsection 1, and not later than 18 months after the said date, if the petition is not withdrawn in the meantime, the court shall, on being satisfied, after hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized, number one, that the marriage is in existence, and that the averments in the petition are true. Whatever they have mentioned in the petition mutually, they are true. Then the court will pass a decree of divorce declaring the marriage to be dissolved with effect from the date of the decree. So this is the section 13B. But remember, even though section 13B provides for the waiting period of 6 months, the Supreme Court, exercising its extraordinary powers under Article 142 of the Constitution, it can grant a divorce decree without waiting for 6 months. This has been mentioned in Kiran versus Sharad Datta year 2000's case, Supreme Court cases. Supreme Court also held that divorce petition cannot be removed unanimously in Sushrita Devi's case. It also said that silence or failure to appear at proceedings would not constitute withdrawal of consent. Now let us talk about the Muslim law. First of all, it is the khula. Khula is, in fact, it is a divorce right which is purchased by a wife from her husband. Remember the word purchased. This has been mentioned in Munshi Buzlu Ul Rahim versus Latifunisa case 1961, and this has been mentioned by Lordship of Judicial Commission. So this khula, it occurs with wife's permission and at her request, in which she gives or promises to give a consideration, certain amount to the husband in exchange for her freedom from the marriage tie. It refers to a contract entered into with the aim of ending a sexual relationship in exchange for compensation given by the woman to her husband from her assets. So this is the purchase of right. Now let us talk about the another concept, that is mubarat. So mubarat means release. It puts an end to matrimonial rights. It is an act of freeing one from another mutually. So it is a mutual discharge from marriage tie. And divorce by mutual consent of husband and wife, that is mubarat. And aversion in mubarat is mutual. So proposal for divorce may emanate from either husband or wife, whatever. It is mutual. Under Shia law, parties can dissolve their marriage by way of mubarat if it is impossible for them to continue. And to enter into mubarat, both parties must be of sound mind and they must have attained puberty. So these are the two basic conditions, that is sound mind and puberty. Also, it says Formalities, what are the formalities? They are same as in case of khula. If both parties are bona fide, they find marital relationship to be irksome, then only marriage stands dissolved. Since both parties are equally interested in dissolution of marriage, no party is legally required to compensate the other by giving some consideration. So payment of compensation is not essential condition for this kind of divorce. Sunni law and Shia law, they differ a little. In case of Sunni, there is no particular form, but mutual agreement must be made at the same meeting and the word Mubarak must be clearly expressed in the proposal so that they can understand it is a mutual divorce. If ambiguous expressions are used, then the intention must be proved. And the parties enter into a Mubarak in Sunni law, all mutual rights and obligations come to an end. In case of Shia law, there has to be the proper form, and Mubarak must be expressed in Arabic language. That is also required. And expression Mubarak must be clearly expressed. Mutual agreement must be made at the same meeting, but two witnesses' presence is a must in case of Shia law. Muslim law, there are more than one form of ways through which marriage can be solemnized and divorce can be initiated for dissolution of marriage. To cater to needs of changing circumstances along with Muslim personal laws, certain legislations are brought by Government of India such as Muslim Dissolution of Marriage Act 1939, pre-independence, then Muslim Women Protection of Rights on Marriage Act 2019, the latest one. These are to govern the Muslim marriage and divorce both. However, apart from these legislations and personal laws, there is a need for UCC, that is Uniform Civil Code, for creating single uniform laws covering all citizens of the nation to strengthen national unity and integrity. Let us conclude this mutually. So, thank you all for today's discussion, divorce by mutual consent in Hindu and Muslim law. Thank you.